Hello, my name is Dan Albert, and this is assignment 4 for IMK 672, Internet and the Law, course 11 of 12 in the Internet Marketing Master of Science program at Full Sail University. The purpose of this video is to discuss my thoughts concerning my reading and analysis of the terms and conditions of use for the website Priceline.com. As a disclaimer, I'm not an attorney, and statements made in this video are solely my own opinion and should not be considered legal advice by any stretch of the imagination. Priceline.com, a wholly owned subsidiary of the Priceline Group, is an American company and a commercial website that claims to help users obtain discount rates for travel-related purchases, such as airline tickets and hotel stays. The company is not a direct supplier of these services. Instead, it facilitates the provision of travel services by its suppliers to its customers. It is headquartered in Norwalk, Connecticut. Priceline was founded in 1997, and a significant portion of their stock is currently owned by Chung Kong Holdings, a company headquartered in Hong Kong. Priceline first became known for its Name Your Own Price system, where travelers would name their price for airline tickets, hotel rooms, car rentals, and vacation packages. While the purchasers can select a general location, service level, and price, the hotel, rental car company, and/or airline, as well as the exact location of the hotel and exact flight itinerary, is disclosed only after the purchase has gone through, with no rights to cancel. In 2016, the Priceline Group did $68.1 billion in bookings. First, a little background on how terms and conditions generally work when it comes to using websites on the internet. Terms and conditions generally come in one of two flavors, click wrap and browse wrap. Click wrap occurs when a user is presented with the terms and conditions of the site up front and must click I agree or checkbox that they agree to the terms before clicking OK to enter the site. For browse wrap, the terms and conditions are present somewhere on the website and are accessible to view from a link, typically at the bottom of the homepage and/or every page on the site. Companies that use browse wrap assume that every website visitor is subject to the terms and conditions by the mere act of using the site, whether or not they ever read them. Priceline.com uses the browse wrap format for its terms of service. Generally speaking, courts don't enforce browse wrap agreements because there's no assent from the user. In order to enforce it as a valid contract, Priceline.com would have to prove that any given user had specific knowledge of the terms and conditions. As an example, in Be.In Incorporated versus Google Incorporated, a social media developer alleged that defendants Google Incorporated, YouTube, and Google UK breached the CamUp website's terms of service by visiting the CamUp website to copy and exploit the website for the defendant's social network platform. The homepage of the CamUp website included a link to the terms of service which stated that by using and/or visiting this website, you signify your agreement to these terms of use and CamUp's privacy policy. A district court in the Northern District of California found that the plaintiff failed to allege a contract was formed because beyond the existence of a hyperlink, there were no other allegations showing that the defendants were on notice that the mere use of the website would be interpreted as an agreement for the terms of service. Specifically, the plaintiff did not allege the size or typeface of the link, the central or obvious location of the link on the webpage, or even the text of the link. Accordingly, the plaintiff's browse wrap agreement was not binding on the defendants. Priceline.com's use of the browse wrap format appears to put them in a position that weakens their position when it comes to a lawsuit. Having the user actively agree, even forcing them to scroll to the bottom of the terms and conditions before they agree, would put Priceline.com in a much stronger position when it comes to legal actions from the users. Since website visitors to Priceline.com can invest a significant amount of money on travel, forcing users to actively assent to the terms of service seems like it would virtually go unnoticed when the users sign up to use the site. This leads to the question, if you have a dispute with Priceline, can you sue them? As with most things in the legal world, the answer is, it depends. In this case, it depends almost 100% on whether or not the courts choose to enforce Priceline.com's browse wrap terms and conditions. A majority of the terms and conditions are used to bolster Priceline's position that they only accept binding arbitration or, in some cases, federal small claims court. In several places, they've written statements to the effect of, by using the site, users waive their rights to sue and/or participate in a class action against Priceline. They also place very specific time requirements and prescribe methods on users to file any complaints, while they give themselves flexibility to go outside of time requirements as they see fit. They've even managed to provide their own damage cap in the event they lose in arbitration. The terms and conditions state, if you prevail in the arbitration of any claim against Priceline and are awarded an amount greater than Priceline's last written settlement offer to you, Priceline will pay a minimum recovery of $5,000, and Priceline will reimburse you for all attorney's fees incurred in arbitrating the claims upon which you have prevailed. So, it appears that if they offer you $8,000 to settle arbitration, and the arbitrator finds in your favor and awards $15,000 in damages, they only pay you $5,000 because they said so. As would be expected, Priceline.com's terms and conditions are designed to protect only the company and its vendors, and do little if anything to assure the customer that Priceline will hold up their end of the deal. In fact, they've built an impressive number of outs to protect themselves for almost any contingency. Though I disagree profoundly with their methods, I can't fault them for trying to protect the company from frivolous lawsuits. However, I do fault them for the way they present, or don't present, their terms and conditions to users of the website. My recommendation to Priceline.com would be to include the terms and conditions up front when users create an account on the site, or add the agreement to the checkout process when users purchase services from the site. Either way, make the users scroll to the bottom and check the I agree block before they can continue either setting up an account or checking out. With either approach, Priceline has proof that every user had the opportunity to read and acknowledge the terms and conditions of the website. To conclude, this exercise has been an enlightening experience and emphasizes the mantra of caveat emptor, or let the buyer beware. Thanks for listening, and have a great day.